So very good evening, all the participants. Today, let us start with the NCLT and NCLAT, and then Supreme Court and High Court we can take up tomorrow.
Right, sir.
And so Sunday also we can take a class if you are all ready. So you can write
Fine.
a group, and I think we can.
We can, sir. We can.
Definitely, because we
करते हैं
have
कल,
to
sir.
complete the syllabus also.
Right, sir.
So now this Aircel Limited, Section 14. So what Section 14 says? Section 14 says that during moratorium, essential goods and services cannot be stopped. Then there are certain critical inputs. And suppose there are licenses, permits, etc. So what will become of those scenarios in case he doesn't pay? So this case describes you what will be the position in case some license, quota, permit, like this spectrum license. Suppose payment is not made or payment is made for current use only. So what will happen in that scenario? So this NCLT case law, which is Aircel Limited, it talks of this thing. So in this case, what the debtor company did, the debtor company had defaulted. Just a minute. बड़ा बड़ा कैसे हो रहा है? Yes. So here, the debtor company, they had defaulted in payment of annual installments. So telecom licenses and grant of spectrum terminated during the moratorium period by Department of Telecom. So the question which arose here was that suppose its spectrum license of a telecom service provider is terminated, then who will buy that company? So that company will be of no value. So that is the issue which is being decided. So the most important feature of holding the spectrum and the license is that the telecom licenses and spectrum are required for operation of the petitioner company as a going concern. So because during CIRP, you have to keep it as a going concern, and naturally both are, you can say, valuable, or rather you can say indispensable. Indispensable will be better word, indispensable assets for the company. So the issue was whether these telecom licenses and grant of spectrum come under supply of essential goods or services. Because earlier, this clause was not there. This clause regarding, I'll open a copy of the Bear Code also, and you can open section 14 also side by side. So section 14, if you see, so what section 14 says? Section 14 explanation. So this explanation was inserted by the Insolvency and Bankruptcy Code Amendment Act 2020, dated 13/3, and with effect from 28/12/2019.
Yes, sir.
This was the issue basically. So whether telecom licenses and grant of spectrum come under supply of essential goods or services, and to declare that the moratorium under Section 14 applies to all licenses, including the telecom licenses granted by the respondent and spectrum purchased by the Aircel Limited and Dish Wireless Limited, as well as petitioner companies' unpaid dues if to the Union of India. So this was the issue. So Department of Telecom was directed not to take any action, not to take any coercive action against the company, such as termination of telecom licenses and spectrum allocation, to refrain from suspending, terminating, and or taking any other action against the petitioner company in relation to the telecom license and spectrum allocation. So whenever they ask this question, so what they will do? They will ask you about the spectrum license, termination, and all those things. Further, direct the respondent from taking any action, steps against the petitioner company in relation to any unpaid dues. So this was the issue, basically. So what were the arguments put forth? The arguments put forth were that the ownership and control over the spectrum at all times is the property of the Union of India and never vested with the licensee. Union of India has exclusive ownership right over the spectrum, and according to him, in this case, the default of non-payment of license fees had already occurred. Therefore, the licensor or DOT otherwise has the right to terminate the impugned facility to the company. So petitioner company was here granted the right to use and not the right to own the spectrum, because spectrum is a natural resource. So they say that everybody can be granted only the right to use and not the right to own. So as per the provisions of section 18(1)(f), of IBC to be read with explanation. An asset, if owned by the third party but in possession of the corporate debtor, can be repatriated back to the owner. So explanation to 18(1)(f) of the code says that an asset owned by a third party but in possession of the corporate debtor held under contractual arrangement shall not be over which the resolution professional can take control. So renewable is at sole discretion of the licensor or DOT. So these were the arguments put forth. Now what was the decision? So the decision the NCLT held here that this without license the company will be as good as a zero. It will be good as good as a shell company, and without such an asset, no party shall take an interest. The idea of IBC is resolution, not liquidation. So nobody will take interest in acquiring this debtor company. So preamble of the insolvency code, where it is prescribed to maximize the assets of the company as well as to protect the value. So to get good resolution plan for the revival of the debtor company. So DOT is instructed not to cancel the license. So these were the brief facts of the case. Now let us see this Adhunik Metallics case. What this Adhunik Metallics case says. So this Adhunik Metallic case, in this case, just a minute. So the application was filed under section 60 subsection 5 of the code. So if you open section 60 subsection 5, so section 60 subsection 5 allows you to file the application on certain grounds. So what it says? Section 60 subsection 5, if you say, it says that notwithstanding anything to the contrary contained in any other law for the timing in force, the NCLT shall have jurisdiction to entertain or dispose of any application or proceeding by or against the corporate debtor or corporate person. Just a minute. Any claim made by or against the corporate debtor or corporate person, including claims made by or against any of its subsidiaries, any question of priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceedings of the corporate debtor or corporate persons under this code. So these are some of the grounds on which the NCLT can take action or they can entertain or dispose of the application. So here, this application was filed under section 60 subsection 5. So what were the facts of the case? The facts of the case were that this Liberty House was the successful resolution applicant, but there was a failure to implement the resolution plan. And not only failure, but a period of almost 1 year had elapsed from the date of the approval of the resolution plan. And that there are various costs, including costs incurred and accrued for salary of workman employee, administration during this aforesaid period. So during this non-implementation of the period, so there are certain costs because all these cases come when there is no answer in the code. So here, there is no answer in the code that how this cost will be treated. So how the cost which is incurred after the approval of the resolution plan will be treated, there is no answer in the IBC. So these costs are incurred in the hope of the revival of the corporate debtor as a going concern. However, that didn't work out, and on 8th July, the company was sent into liquidation. So the applicant here is the liquidator of the corporate debtor company and was so appointed when the liquidation order was passed on 8th of July by this bench. So at the aforesaid application, the applicant has sought clarity about the treatment of claims received on and from the period between 18th July 2018, that is the approval of the resolution plan, till 7th July, when the company was supposed to be revived under the resolution plan, approved on 17th July. So this is the issue involved basically. So clarification is required in regard to the treatment of aforesaid claims of workmen and employees and such other claims which have accrued during the non-implementation period, and whether the same should have priority over other dues. This is the question basically. So it has been noted that the distribution pattern of the assets and the order of priority have been specified under section 53, because section 53 talks of the waterfall mechanism, how the things will be treated. Further, the insolvency resolution process cost and liquidation costs have already been defined under section 513 and 516. So the claims received during the period between 18th July and till 7th July 2019 can neither be treated as part of insolvency resolution process cost, nor do they fall within the ambit of liquidation cost, and hence cannot be accorded priority over other dues in terms of the provisions of the law. So the basic point here was that if they are brought either under insolvency resolution or under liquidation, then they will be accorded priority as per 53(1). So they say that this cost which is incurred once the resolution plan stands approved and during the non-implementation of the resolution plan, if there is any cost, that cost is neither insolvency resolution process cost nor liquidation, and they cannot be accorded priority over other dues. However, in respect of the aforesaid claims received during the period between 18th July till 7th July 2019, applicant may rely on the statutory treatment of claims as laid down in section 53 of IBC. So they will be treated as any other claim. So they can be treated as statutory claims, basically. That is the how this claims will be treated. So they will neither be treated as insolvency resolution process cost nor liquidation cost. This was the issue.
So it means it has gone to the status of statutory dues like state government, central government, other dues.
Because these were the basically dues of the employees, salaries or employees. So natural administration costs, to security personnel and other professional fees of auditors. So they will be paid as per the claims, as per section 53 only. Hanji, any other views on this? युवराज तिवारी जी?
53 में जाएंगे, मतलब वो तो एम्प्लॉय कोस्ट जो जिस क्लॉज में फॉल करता है उसी क्लॉज में चला
हाँ,
जाएगा।
जो जिसमें जाता है उसमें जाएगा। हाँ, बिल्कुल बिल्कुल। जेट एयरवेज केस, जेट एयरवेज में क्या हुआ? जेट एयर में ये था कि जो रेजोल्यूशन प्रोफेशनल था जेट एयरवेज का, दे हैड फाइल्ड एन एप्लीकेशन फॉर अप्रूवल ऑफ ट्रिब्यूनल फॉर सेल ऑफ वन ऑफ द नॉन कोर एसेट्स ऑफ द कॉर्पोरेट डेटर. So this question arose here, whether non-core assets which are secured, whether they can be sold during CIRP period. This is the basic issue. To clear overseas debts of Jet Airways, to ensure 6 aircrafts are freed from encumbrances, so that it would hugely maximize the value of the corporate debtor during CIRP period. This was the issue. So the issue here was whether the non-core assets of the corporate debtor on which security interest has already been created in favor of HDFC can be sold with the consent of COC and the security interest holder to get the title of the 6 aircrafts. So this was the issue, basically. So this application was allowed, and they said that there is no objection either from any member of the COC or from the charge holder of the premises, that is HDFC. Apart from this, for there being huge value addition to the corporate debtor, the bench allowed this application, approving the resolution approved by the COC. So this allowed this. So they permitted the sale of non-core assets. So the applicant is hereby permitted to sell the premises for utilizing the proceeds of the sale of the 3rd and 4th floor to settle the claims of HDFC. So basically, these non-core assets, which consisted of premises, so these premises were allowed to be sold, and these premises were utilized to settle the claims of HDFC at INR 360 crores. HDFC giving up security interest, charge or any other rights in respect of the premises and withdrawing the pending applications simultaneously against receipt of the above sum of 360 crores with no responsibility or liability on HDFC towards any other costs, charges, claims in connection with the insolvency resolution process. However, including in the event of any liquidation of the corporate debtor and HDFC, they may charge the security or interest rights, and HDFC charge security, interest and rights, and premises shall remain unaffected until receipt of the full sum of INR. So HDFC basically said that you give us our 360 crores, so do whatever you want to like. Basically, this is the issue. And in case there is liquidation despite this, then we can exercise our charge. So this was the basic issue.
Sir, whether this can be accepted, sir? See, in the case of anyway, they have security interest, HDFC.
but they relinquished it now during CIRP. So basically, these, as I told you earlier, all these cases, they are basically deciding the issues which are not there in the code. Because if there is anything in the code, so then it will be decided as per the code. But they say any question of priorities or any question of law or facts. So basically, NCLT can decide on anything. So they said that, okay, HDFC has got the charge. These are non-core assets. Taken on. So non-core assets in any way do not affect the working of the company. They do not affect the going concern status also. There are so many issues here. So if they do not affect the going concern status and these are non-core assets and the secured creditor is ready to relinquish its charge, so they can sell it. And they settle this US Exim and CIRP costs. So case laws, you have to read as it is. You don't have to bring the understanding of the case laws into understanding of the code. Because these are as per the syllabus only. So you have to restrict your understanding of the case laws only to these case laws while answering these case laws. So they will be asking you questions on case laws, but these understanding, you cannot bring them to the
Law.
law, because every issue will have its own peculiar questions,
Nature,
its
yeah,
own
yeah.
peculiar circumstances. So based on that, they have given a judgment, and single judgment cannot be applied to the other issues. So that is the basic understanding you have to keep in mind.
Right, sir.
Now, this Bharti Defense and Infrastructure. So what was the case here? So facts of the case was that this CIRP of Bharti Defense and Infrastructure, it was initiated by Edelweiss Asset Reconstruction Company. Okay. So it was a financial creditor and it has got huge outstanding of 9,000 crores, out of which the loan IDBI was given as working capital facility to the corporate debtor has been assigned to this Edelweiss. So loan was initially given by Edelweiss, but it was assigned to loan was given by IDBI, but it was assigned to Edelweiss, and they filed the application under Section 7. And the corporate debtor, they defaulted in paying debt to IDBI, and having this applicant stepped into the shoes of IDBI by virtue of assignment agreement, this applicant has filed this case. So Edelweiss filed this case. So first is whether there is an issue in filing this application under Section 7. So it says, what were the arguments put forth? A record of default in respect of this claim is not in existence with information utility. So this was one issue. Second is, claims made by the applicant is not an adjudicated claim, therefore not a debt. Applicant does not fall within the definition of financial creditor. Petition is not maintainable as there are company petitions pending against the debtor company before the Honorable High Court of Bombay. Therefore, winding up proceedings cannot be done simultaneously. So many things they decided in this Bharti defense. First was this non-filing of record from the information utility. So they say the information utility, so it was not fully operational under the law by the time this petition was filed. Further, filing of record of default with the information utility is only optional. If it is available, it can be filed. For this reason alone, in Regulation 8, it has been said that if any information is available, so it may be proved by that mode, or else the creditor can file other records to prove the default. Therefore, the objection on the ground of non-filing of record from information utility will not make this petition invalid. Second is the definition of financial creditor. In the trust deed itself, it has been mentioned that this applicant as trustee can deal in all respects with respect to the trust and its assets. For this reason, we are of the view that this applicant is competent to file this petition as an applicant. Therefore, this objection raised by the corporate debtor is invalid. Second is, company petitions are pending. This point is also raised. So in view of bar of jurisdiction under Section 63 and overriding effect on all other laws under Section 238, pending of proceedings in respect of this claim before any other court will not become a bar to entertain this petition under Section 7. Therefore, the objection raised by the corporate debtor has no merit, because if you see Section 63, Section 63 also says civil court not to have any jurisdiction. So it says that the debtor company has defaulted in repaying its debts to the financial creditor. And So
Sir,
they,
can you change the slide?
Yeah,
okay,
please.
okay.
Thank you.
So they said the debtor company has defaulted in repaying its debts to the financial creditor, and therefore CIRP has been admitted. Now this Viceroy Hotels Limited. Viceroy Hotels Limited, what was the case basically? The case was that the resolution number 4 and 7 for conducting a forensic audit of corporate data was passed by members of the COC with 59.21% vote share. Because in IBC, you will see that there are various percentages which are required for passing different types of resolution. Sometimes it is not less than 51%, sometimes it is not less than 66%. So based on, because all actions which are given in section 28, so they require approval of not less than 66%. But there is another section which says not less than 51%, sorry, 51%. कौन सा section है 22 है 24 है क्या?
21
22 में हूँ सर, meeting of the creditors.
21 subsection 8.
हाँ
27.
22 subsection 8. It says, save as otherwise provided in this code, all decisions of the committee of creditors shall be taken by a vote of not less than 51% of the voting share of the financial creditors. So section 22 subsection 8. 22 or 21 है?
Sir, 21
हाँ,
ही होता है.
21 का 8 है, 21 का, हाँ. So this resolution professional contended that these are not approved as 66% voting is required for the same. However, the applicant is of the view that only 51% is required. So the issues involved were, what are the circumstances where 51% is required, where 66 is required? So both the above resolutions were required to be approved by 51% of the COC as per section 21 subsection 8 of the IBC. However, the resolution professional contended that they need to be passed by 66%. So they said that a resolution for making the changes in the appointment or terms of contract of statutory auditors or internal auditors. So they say section 28 also refers to some similar situation. So section 28, if you see, so that says that if any change is required in the terms and conditions, what is that? Section 28,
L&M, sir.
21, 28(1)(m), make changes in the appointment or terms of contract of statutory auditors or internal auditors of the corporate data. So they said that this resolution does not fall within 28(1)(m) of the code, and it needs to be approved by vote of not less than 51% and not 66%. Similarly, resolution number 4, it does not fall in any of the categories mentioned in section 28(1). Therefore, it needs approval of 51%. So since the both resolutions are approved with 59.21% votes, so they are declared to be passed with the requisite majority. So this was the question, that what are the actions which require 51%, not less than 51%, and what are the actions which require 66%. So basically, what 28(1)(m) says, the make changes in the appointment or terms of contract of statutory auditors or internal auditors of the corporate data. So only if the resolution is regarding this point, only then it requires 66% majority. What is the idea behind 28(1)(f)? The idea behind 28(1)(f) is that they want to see that the statutory auditors or internal auditors can work freely. So they are not under pressure. So it requires the COC, and it is not the whims and fancy of the resolution professional itself. So basically, so COC approval is required. So the COC will consider this matter, that if there are any changes in the appointment or terms of contract of the statutory auditors or internal auditors, only they will approve with 66% majority. Other decisions are of ordinary majority with not less than 51%. Bhatia Coke. So Bhatia Coke, what was the case? So here the case was that a nationalized bank holding 32% of the voting share in the COC had all the options. So basically, sometimes what happens is that they vote under protest. So sometimes what they do, they say we are voting under protest. Now, what is this voting under protest? If you are voting in favor of the resolution plan, then you cannot say we are voting under protest. So that is not, so it means you are having a rethinking. So this is the case basically. So a nationalized bank, which is holding 32% of the voting share in the COC, had all the options to vote against the plan for file applications or even take up an application for change of RP if they wish to do so. However, in the above case, SBI, after voting in favor, files an application that there was no commercial wisdom. So once you have voted in favor, then how can you say that I voted under protest or there was no commercial wisdom? So the issues involved was whether there is any violation of regulations. Final revised application was not placed before COC for detailed deliberation. Hence, collective wisdom could not be arrived. And applicant voted in favor of resolution plan under protest to avoid liquidation. So what were the arguments put forth? So NCLT said that there is no procedural irregularity in submission of the resolution plan to COC, and applicant also participated in the 21st meeting of COC, where details of the resolution plan were deliberated. And on voting, it was 100% approved, including applicant's vote. So here 32% votes here, and he voted in favor, but he said that I am voting under protest. Even if applicant had voted against, his share was just 32%. भाई देखो ऐसा है, कोई आपका प्लान 100% से अप्रूव हो गया, अब 32 वाले ने मान लीजिए प्रोटेस्ट को निकाल भी दे तो भी 68 बच जाता है, तो 68 पर भी अप्रूव हो जाता. So and 66% requirement would still be met. So application is not maintainable as applicant themselves voted in favor, and they are barred to do so to change their opinion basically. So what is the analysis and decision? This application is not maintainable as applicant himself voted in favor of the resolution plan at COC meeting, and there is no provision in IBC to vote under protest. ऐसा कुछ under protest का कुछ option नहीं है, ठीक है? And voting in favor implies commercial wisdom, and there is no ambiguity in the minds of the creators. So applicant having voted in favor of the resolution plan is stopped from filing such application. If the applicant is unable to arrive at a conclusion regarding the resolution plan, it appears that there is a lack of clarity in the commercial wisdom in the minds of the applicant. Tribunal cannot allow members who have acted in favor of the resolution plan and subsequently come up with another new commercial wisdom regarding the viability of the plan and the procedural lapse of the RP. Such application will only lead to absolute chaos. And if such applications are entertained, then no resolution plan can be completed on time. Regarding maintainability of application, so they said that adjudicating authority is duty bound to address issues like procedural irregularities in the conduct of COC meeting and about RP at the time of approval of the resolution plan when the same was placed before it. Another issue was whether physical COC meeting was compulsory, particularly during pandemic. So commercial wisdom can be arrived by physical meeting as well as by virtual meeting. So you can have audio visual means of communication. So sitting together to deliberate is not necessary, especially in case of pandemic. So these were the issues. Now let us see quickly. NCLT. Yes.
Sir, Bhatia Co case, which I have read, is relating to some OTS matter.
अच्छा, देखिए ऐसा है, वो ना आप एक बार उसको मिला लीजिएगा उससे साइटेशन से, फिर बाकी कल तो हम कर ही रहे हैं, कल डिस्कस कर लेंगे, कोई इशू नहीं है.
ओके सर, ओके ओके.
हेलो,
ठीक है सर.
ठीक है विवेक सूद जी.
ठीक है सर, मैं
आप मुझे लिख दीजिएगा, एक बार साइटेशन मिला लीजिएगा.
राइट सर, राइट सर.
क्योंकि क्या होता है, एक बहुत सारे केसेस होते हैं सेम मैटर पर भी.
जी जी.
अगर उस वजह से हो सकता है, और नहीं तो कल तो डिस्कस कर ही लेंगे, कोई दिक्कत नहीं. एनसीएलटी केस लॉज कुछ डिस्कस कर लेते हैं. एनसीएलटी केस लॉज में क्या है, जैसे एक तो है इसका,
I think one more case is there, sir. I think that was missed. I think Videocon case is there, no?
Infrastructure is missed, sir.
हाँ नहीं वो मिस किया है, जानबूझ के मिस किया है, वो बाकी बाद में करेंगे. अभी आज इतने ही डिस्कस करेंगे, कुछ कुछ केस लॉज मैंने आइडेंटिफाई किए हैं, बाकी कल कर लेंगे.
Okay, okay.
ठीक है जी. हाँ
आप सर ये मटेरियल शेयर कर दीजिएगा जो आपने प्रेजेंट किया ना, ये शेयर कर दीजिए.
मेरे ख्याल तो ग्रुप में ऑलरेडी शेयर्ड है, मैं दोबारा शेयर कर दूंगा.
दोबारा कर दीजिए.
मैं कर दूंगा, पक्का पक्का डेफिनेटली. हाँ जी. तो अब ये वाला केस लॉ जी आपका गैमन इंडिया का. गैमन इंडिया में क्या हुआ था बेसिकली, ये नीलकंठ मेंशन्स एंड इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड. अब in real estate, what you normally find is that they form special purpose vehicles. And suppose they form a partnership company, and one of the partners of the company is one of the partners of the partnership firm is a company, because a company can also be a partner in a partnership company. So that was the issue basically here. So by an agreement dated 17th June, the appellant had entered into partnership to be known as Gammon Neelkanth Realty Corporation. बिटवीन द नीलकंठ मेंशन, इसमें कौन, 3 कंपनीज थी, एक तो थी नीलकंठ मेंशंस एंड इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड, ठीक है, और 2 एंटिटीज थी, नीलकंठ रियल्टर्स प्राइवेट लिमिटेड, और तीसरी थी गेमन हाउसिंग एंड एस्टेट्स डेवलपर्स लिमिटेड, ठीक है। ये तीनों कंपनी इन्होंने एक पार्टनरशिप बनाई, ठीक है, फॉर एक्सिक्यूटिंग ए प्रोजेक्ट, और उस पार्टनरशिप का नाम क्या रखा, गेमन नीलकंठ रियलिटी कॉर्पोरेशन। So originally, the appellant Gammon India Limited filed petition under section 433E जब ये IBC नहीं आया था, ठीक है। तो इन्होंने क्या किया था, इन्होंने बॉम्बे हाई कोर्ट में एक पिटीशन फाइल की थी फॉर वाइंडिंग अप ऑफ नीलकंठ मेंशन एंड इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड ऑन द ग्राउंड दैट द कॉर्पोरेट डेटर डिफॉल्टेड इन मेकिंग पेमेंट। अब जब IBC आ गया तो दिस एप्लीकेशन वाज फाइल्ड अंडर IBC. After enactment of IBC, the case was transferred to the adjudicating authority, which leads to transfer of pending proceedings of winding up on the ground of inability to pay the debts. तो इन्होंने क्या किया, सेक्शन 9 की एप्लीकेशन लगा दी फॉर इनिशिएशन ऑफ CIRP अगेंस्ट नीलकंठ मेंशंस एंड इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड. Our adjudicating authority by impugned order dismissed the application under section 9 on the ground that the application under section 9 is not maintainable against the partnership firm. इन्होंने कहा भाई पार्टनरशिप फर्म के अगेंस्ट में तो सेक्शन 9 में एप्लीकेशन एडमिट नहीं हो सकती. कोर्ट, आप ध्यान रखिए कि कोर्ट क्या करता है, कोर्ट उतनी ही बात का आंसर करता है जितनी बात उससे पूछी है, ठीक है ना, उससे ज्यादा नहीं वो आंसर करते. अब आपने अगर सेक्शन 9 की एप्लीकेशन लगाई है तो वो ये नहीं कहेंगे भाई किस सेक्शन में एप्लीकेशन लगाओ क्या करो, वो ये कहेंगे भाई यहाँ नहीं लग सकती सेक्शन में, वो हम एडमिट नहीं कर. तो इन्होंने जब एप्लीकेशन लगाई तो उन्होंने कहा भाई ये जो नीलकंठ गैमन नीलकंठ रियल्टी कॉर्पोरेशन है ये तो एक पार्टनरशिप फर्म है, तो इसके अगेंस्ट में आप एप्लीकेशन नहीं लगा सकते. तो इशू क्या था, वेदर सेक्शन 9 पिटिशन इज मेंटेनेबल अगेंस्ट वन ऑफ द पार्टनर्स ऑफ पार्टनरशिप फर्म in a partnership firm where all or any of the partners are company, whether CIRP under section 9 is maintainable. So this was the issue basically. Now what were the arguments put forth? इसमें ये कहा कि only when a firm is comprised of individuals, that is to say natural persons, then the provisions of part 3 of the code will get attracted. In case 2 or more persons, whether artificial or legal, and who are not individuals, are carrying on the business in partnership, then application for insolvency resolution against such partnership cannot be entertained by the adjudicating authority due to lack of jurisdiction. In that view of the matter, the application under section 9 was filed against one of the partners, which is a legal entity, corporate body, and not an individual. So the point was, it is not in dispute that the amount due to the appellant is from the Gammon Neelkanth Realty Corporation. भाई पैसे लेने किससे आपने लेने हैं पार्टनरशिप फर्म से, ठीक है. तो पार्टनरशिप फर्म के अगेंस्ट में आप IBC की एप्लीकेशन लगाओ ना, आप उसके एक पार्टनर के अगेंस्ट में तो एप्लीकेशन नहीं लगा सकते ना, जो कि एक कंपनी है, सेक्शन 9 में नहीं लगा सकते. मेन बात ये है. So the bill was raised against the said partnership firm, Gammon Neelkanth Realty Corporation, Neelkanth Realty Realtors Private Limited, Gammon Housing and Estate Developers, and Neelkanth Mansions. These are the partners. ठीक है, चाहे corporate entities हैं, but these are the partners. Therefore, even if one of the partners or more than one partner is the corporate debtor, as the amount is due from the partnership firm, the application under section 9 of the code against one of the partners of such partnership firm will not be maintainable. तो अब ये NCLAT ने कहा, ठीक है, NCLT ने तो रिजेक्ट कर ही दिया था, अभी NCLAT में पहुंच गए. तो NCLAT ने भी ये कहा कि NCLT का जो जजमेंट है वो ठीक है, ठीक है. NCLT ने भी रिजेक्ट की थी इनकी एप्लीकेशन. The adjudicating authority has rightly held that the application under section 9 was not maintainable against one of the members of the partnership firm and rightly rejected the said application. नेक्स्ट केस देख लेते हैं हम, ये है आपका
Parasna Ispat.
हाँ, ये वर्सन्ना इस्पात, हाँ।
जी सर, पीएमएलए।
वर्सन्ना इस्पात, वर्सन्ना इस्पात में क्या है, ये पीएमएलए वाला केस है। इस केस में हुआ क्या था, द डायरेक्टरेट ऑफ एनफोर्समेंट ऑफ सेंट्रल गवर्नमेंट न्यू दिल्ली अटैच्ड सम ऑफ द प्रॉपर्टीज ऑफ वर्सन्ना इस्पात लिमिटेड। ठीक है, द रेजोल्यूशन प्रोफेशनल फाइल्ड एप्लीकेशन बिफोर द एडजुडिकेटिंग अथॉरिटी कोलकाता बेंच फॉर रिलीजिंग द अटैचमेंट ऑफ सर्टेन एसेट्स ऑफ द कॉर्पोरेट डेटर बाय डिप्टी डायरेक्टर ऑफ एनफोर्समेंट। अब होता क्या है कि जब सीआईआरपी स्टार्ट होती है तो आरपी कहता है भाई जो भी अटैचमेंट है वो वेकेट करो, है ना। तो यही इशू है। तो आरपी ने एप्लीकेशन फाइल की फॉर वेकेशन ऑफ अटैचमेंट ऑफ सर्टेन एसेट्स ऑफ द सीडी, ठीक है, जो कि डिप्टी डायरेक्टरेट ऑफ एनफोर्समेंट ने अटैच किए हुए थे। द अटैचमेंट ऑर्डर वाज इशूड ऑन 10th of July, क्योंकि टाइमिंग इज ऑल्सो इंपॉर्टेंट कि वो अटैचमेंट ऑर्डर इशू कब किया, क्या सीआईआरपी डेट से पहले का है, सीआईआरपी डेट के बाद का है, प्रोविजनल अटैचमेंट ऑर्डर है, फाइनल अटैचमेंट ऑर्डर है। सो दीज आर मैनी, देयर आर मैनी इश्यूज, है कि नहीं। तो द अटैचमेंट ऑर्डर वाज इशूड ऑन 10th of July प्रायर टू द ऑर्डर ऑफ डिक्लेरेशन ऑफ मॉरेटोरियम, यहाँ पर, ठीक है। Therefore, an order releasing the order of attachment by the Directorate of Enforcement is not maintainable. The aforesaid order dated 12th July is under challenge in this appeal. ठीक है, तो एनसीएलटी ने क्या किया था, एनसीएलटी ने कह दिया था कि भाई रिलीज कर दो अटैचमेंट, ठीक है। इन्होंने कह दिया कि भाई ये वाला जो है मेंटेन, ये इसी को चैलेंज कर दिया। तो इशू इन्वॉल्व क्या था कि whether the order of attachment by the enforcement directorate is maintainable, whether section 14 of the code is applicable to criminal proceedings or any penal action pursuant to criminal proceedings or any act having essence of crime or crime proceeds, whether PMLA overrides IBC, क्योंकि ये PMLA में अटैच किए थे। Now what were the arguments put forth? Argument put forth was that section 14 of the IBC has an overriding effect on the provisions of PMLA. So reference was made to section 238 of the code. It was submitted that during the period of moratorium, the creditors and all authorities causing any disruption in the CIRP cannot be allowed to do so. And the provisional order of attachment cannot be confirmed by the Directorate of Enforcement during the period of moratorium.
Sir, please change the slide, sir.
हाँ, ठीक है जी, आप नजर आ रहा, हाँ। सो the Prevention of Money Laundering Act, actually it relates to proceeds of crime and the offense relating to money laundering resulting in confiscation of property derived from or involved in money laundering and for matters connected therewith or incidental thereto. So thus, as PMLA or the provisions therein relates to proceeds of crime, we hold that section 14 of is not applicable to such proceedings. So they said that the PMLA is referring to proceeds of crime and section 14 is not applicable. So moratorium will not applicable in case of criminal proceedings. Insofar as penalty is concerned, offense of money laundering is punishable with rigorous imprisonment, which is not less than 3 years and has nothing to do with the corporate debtor. Okay? It will be applicable to individual, which may include the ex-directors and shareholders of the corporate debtor, and they cannot be given any protection from the Prevention of Money Laundering Act 2002. And such individual cannot take any advantage of section 14 of the IBC. So this apart, we find that the attachments were made by the Deputy Directorate much prior to the initiation of CIRP. So timing is also important. One is that PMLA, whether it section 14 operates in case of criminal proceedings also. Second is whether the proceedings are against the director or the company. And the third issue is whether the attachments were made prior to the CIRP date or after that. So therefore, the resolution professional cannot derive any advantage out of section 14. So as the Prevention of Money Laundering Act relates to different fields of penal action of proceeds of crime, it invokes simultaneously with the IBC, having no riding effect of the one act over the other, including the IBC. So the appeal is therefore dismissed. So therefore, they dismissed this appeal of the RP basically. Next case is Liberty House Group Private Limited. Just a minute. तो लिबर्टी हाउस ग्रुप में केस क्या था? इसमें केस ये था, द स्टेट बैंक ऑफ इंडिया दे फाइल्ड 2 separate applications under section 7 of the IBC, one against the Adhunik Metallics and another against Geon Steel Limited, the subsidiary of Adhunik Metallics Limited. ठीक है? In both the CIRP, ये जो लिबर्टी हाउस ग्रुप था, they filed the resolution plan and they became the successful resolution applicants. ठीक है? Both the resolution plans were approved by the adjudicating authority. Liberty House Group initially moved before the adjudicating authority, bringing certain facts of non-implementation of certain agreements in terms of the resolution plan by the committee of creditors, which having rejected, it preferred the appeal before this appellate tribunal. क्योंकि इसने कहा कि भाई मुझे देखो इम्प्लीमेंटेशन में इश्यूज आ रहे हैं, लिबर्टी हाउस ग्रुप ने बोला जितनी मुझे साइट्स बताई थी उससे ज्यादा थी, है कि नहीं, हैंड ओवर मुझे नहीं किया गया, बहुत सारी चीजें इन्होंने बताई कि भाई आई एम अनेबल टू इम्प्लीमेंट दिस। ठीक है, पहले एनसीएलटी के पास गया, एनसीएलटी ने रिजेक्ट कर दिया, अब ये गया एनसीएलटी के पास, लिबर्टी हाउस ग्रुप लिमिटेड, जो सक्सेसफुल रेजोल्यूशन एप्लीकेंट था। ठीक है, so for some reasons Liberty House Group Private Limited failed to make upfront payment within 30 days of the extended period. At that stage, the committee of creditors moved an application for reinitiation of the CIRP process and to allow it to consider the other resolution plans on the ground that Liberty House Group Private Limited had failed to implement the plan within the extended period of 30 days. By common impugned order for liquidation of Adhunik Metallics and Geon Steel Limited was passed by NCLT. Okay? Adjudicating authority also refused to grant further time to the committee of creditors to consider the other resolution plans. Subsequently, it was informed that the upfront amount has been paid. अब बात यह है कि once liquidation order has been issued by the NCLT, whether it can be taken back. This was the issue before NCLAT. So they said that both the resolution plans are now being implemented. अब वो कहते हैं भाई देखो अब तो कर रहा है ना implement, पहले नहीं किया, upfront payment नहीं किया, ठीक है, अब तो implement कर रहा है ना. So they said both the resolution plans are now being implemented and Liberty House Group Private Limited on court suggestion has paid additional amount of rupees 10 crores. So we are inclined to interfere with the impugned order of liquidation. So court in exercise of power conferred under Rule 11 of NCLAT rules and to ensure that the CIRP of both the corporate debtors, Adhunik Metallics and Geon Steel Limited, now reaches finality, the committee of creditors, other creditors now have no objection and the liquidation will not be in the interest of both the corporate debtors. वो कहते हैं भाई देखो ऐसा है, हम लिक्विडेशन कर देंगे, लिक्विडेशन से तो फायदा होगा नहीं, अगर ये अब इम्प्लीमेंट कर रहा है तो इसको दोबारा चांस दे दो, करने दो। ठीक है, so they set aside the impugned order of the NCLT dated 9th July. वो जो liquidation order था, they set it aside. So both the resolution plans be implemented in its letter and spirit. The claim of all the creditors stands settled. Control and records of both the corporate debtor, Adhunik Metallics Limited and Geon Steel Limited have already been handed over to the successful resolution applicant by committee of creditors, monitoring committee, resolution personnel, committee of creditors, monitoring committee, resolution personnel, stand discharged. So they said that okay, let's this Liberty House take it over. Okay.
Sir, I have a small question.
Yes, please.
We just did a case on PMLA. So I wanted to understand if suppose some penalties imposed on the company for the PMLA dues, then what will happen to the basically how would the dues be treated actually, the penalties and all?
They will be treated as government dues only. So government dues, section 53(1)(f) if we see, so they will be treated as per section 53.
1E, no, sir?
Yes.
Okay.
If the company goes into liquidation, so then they will be treated and any amount due to central government and state government.
Okay.
Up to 2 years and beyond 2 years, then in 53(1)(f), any remaining debts and dues. And suppose CIRP takes place, ठीक है, अगर मान लीजिए CIRP हो गया, तो CIRP में क्या होगा, दी जो रेजोल्यूशन प्रोफेशनल है दैट विल टेक इट इनटू द अमाउंट. वो आपके पास आप इंफॉर्मेशन मेमोरेंडम बनाते हो ना, तो इंफॉर्मेशन मेमोरेंडम में यू विल इंक्लूड दिस थिंग.
Okay.
One small thing, sir.
Yes, please.
Suppose the central government dues,
Yes.
usually those will be only arisen out of just like it is an operational creditor. If the government is operational creditor, then only it will come, I think. But in this case, that madam has asked whether fines and penalties imposed.
No, actually, first of all, we have to decide whether you are in CIRP or liquidation. If you are in
Yes, it is.
CIRP, then regulation 36 will answer your question. 36 talks of information memorandum. And what they say, assets and liabilities, including contingent liabilities, any claims. So you will include everything here. And whatever resolution plan, details of all material litigation, ongoing investigation or proceeding initiated by the government and statutory authorities. So you will include it in the information memorandum. If it is in CIRP, if it is in liquidation, then the liquidator will have the authority to decide whether it is admissible or not. Otherwise, they will go to NCLT, and NCLT will pass an order.
And in this case, resolution, the information is given in information memorandum.
Yes.
Resolution applicant कहता है कि मैं तो haircut होना है, so I will
तो
give you
ऐसा नहीं,
haircut.
COC will decide ना. See, if
Yes,
COC
yes.
decides with 66% majority, then the
Then
government also has to agree to it ना. वो तो 30 section 31 में लिखा ही है ना.
जी जी जी.
Section 31 में लिखा है कि भाई once the resolution plan stands approved, so it is binding on everyone.
Binding on everyone.
हाँ.
Okay.
Mhm.
And suppose in PMLA, basically it is a criminal proceeding, so direct action is normally taken against the directors. And this 32A or IBC does not grant immunity to the directors. If you are involved in some criminal activity, then you are not granted any immunity, no? Even if the resolution plan stands passed. So they can be.
Yeah, company only will be exonerated, but
Yes,
the directors
yes.
and promoters or whoever. they
Immunity
have-
is granted to company only under section 32A and not to the directors.
Yes, yes. Sir.
So now
Thank you, sir.
this आपका है कुंदन केयर. हाँ, तो कुंदन केयर में क्या हुआ था? कुंदन केयर में ये था कि जो सक्सेसफुल रेजोल्यूशन एप्लीकेंट था कुंदन केयर, they have appealed before NCLAT against the order of the NCLT, rejecting its application for withdrawal of the resolution plan. Basically, the question here is whether once you have submitted the resolution plan and there is inordinate delay by the adjudicating authority in accepting the resolution plan, whether you can take it back. Suppose the resolution plan was passed in, say, 2022 and adjudicating authority takes 2 years. So by the time, suppose pandemic has come or some other issue has come, so the things have now become unworkable for you because you gave your plan based on that situation. Now the situation has changed. So whether you can take back that plan, that is the point. That application for withdrawal of a resolution plan, whether you can make it or not. This is the issue basically. So the successful resolution applicant, Kundan Care Products, has appealed before NCLT against the order of the NCLT, rejecting its application for withdrawal of its resolution plan. NCLT rejected. NCLT said, no, you cannot, once a resolution plan you have submitted, you cannot be allowed to withdraw it. Now they have gone to NCLAT. And cancellation, revocation, return, refund of the performance bank guarantee on the ground that there is no legal basis or justification for holding that an application for withdrawal of a resolution plan post approval is not maintainable. So NCLT rejected it outright. The approved resolution plan had been rendered commercially unviable on account of delay in conclusion of CIRP, and the appellant believed that he could not be prevented from withdrawing the same. So he said that now it has become unviable, so I cannot be prevented from withdrawing the same. So they relied on the judgment of Committee of Creditors of Metlist Forging Limited versus Deccan Value Investors. So the issues involved here were whether after approval of the resolution plan by the Committee of Creditors, when it is lying with the adjudicating authority, so whether adjudicating authority has any jurisdiction to entertain or permit the withdrawal application filed by the resolution applicant. So this application is filed for withdrawing the resolution plan, which stands approved by the COC. This is the issue basically. So the arguments put forth were that once the resolution plan has been approved, it becomes a binding contract between the parties. And the successful resolution applicant cannot be permitted to withdraw the same, which will have the effect of sending the corporate debtor into liquidation. So recent decision of this appellate tribunal in Committee of Creditors of Educomp Limited. So resolution applicant has, so similar issue arose in this Educomp case also. So resolution applicant has accepted the conditions of resolution plan. It was not open to it to make a U-turn and wriggle out of the liabilities imposed upon it under the resolution plan approved by the Committee of Creditors. Now, what was the decision? So cases relied upon is entirely different, as it was violative of section 30 subsection 2E of the code and hence entirely different from present facts of the case. So appeal is being dismissed on the following grounds. So there is no provision in the IBC which allows the successful resolution applicant to withdraw the resolution plan submitted by it. Okay? Once it is approved by the Committee of Creditors with requisite majority. The successful resolution plan incorporates contractual terms binding the resolution applicant, but it is not a contract of personal service which may be legally unenforceable. The resolution applicant in such cases is stopped from wriggling out of the liabilities incurred under the approved resolution plan, and the principles of estoppel by conduct will apply to it. The value of the assets of the corporate debtor is bound to have depleted because of passage of time consumed in the CIRP, and in the event of successful resolution applicant being permitted to walk out with impunity, the corporate debtor's depleting value would leave all stakeholders in a state of devastation. So they said you cannot withdraw it. Now this Ramesh Kimal versus Siemens Commission. So ये case क्या था देख लेते हैं एक बारी. So the application was filed on 11th May. Meanwhile, section 10A was inserted. So section 10A, they said that okay, any application cannot be filed on or after 25th March because the pandemic was there, and notification was issued first for 6 months and then 2 notifications for 3 months each. So for 1 year, they said that okay, if any default occurs during this period, then you cannot file this application. But the issue was that the Gazette notification was published on 5th of June and they made it with retrospective effect from 25th March. So they said that whether you can make it work retrospectively, this was the issue. So if we see section 10A, so it says, notwithstanding anything contained in 7, 9 or 10, no application for initiation of CIRP shall be filed for any default arising on or after 25th March for a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this behalf. So 2 further notifications were issued for 3 months each. So what is the issue involved? The issue involved is whether an application for initiation of CIRP in respect of default committed before 25th March but filed before 5th June, that is the date on which the amending ordinance came into force, in respect of such default would be maintainable in view of the express bar created by the main provisions of section 10A. So what were the arguments put forth? So they said that section 10A cannot be construed to include applications that had already been filed and were pending before the adjudicating authority. This was one issue. And explanation to 10A clarifies that the provisions of section 10A would not apply to any default committed prior to 25th March. So suppose default has occurred, say up to 24th March, and application has been filed after 25th March. So what will happen?
The application will entertain.
So appeal dismissed. So they said that the initiation date is different from commencement date. So date of filing is not important. What is important is the date of admission. According to Form 5, the application to the adjudicating authority, as also in Form 3, that is the demand notice, the OC has specified 30th April as the date of default, which clearly goes beyond the cutoff date. So they said that once you yourself are saying in the application that the date of default is 30th of April, and we are saying that you cannot file any application for default occurring on or after 25th March. So then this application is not maintainable. So this clearly goes beyond the cutoff date. Therefore, the adjudicating authority was perfectly justified in rejecting the application under section 9 of the code at the instance of the appellant operational creditor, as the default has occurred after the cutoff date and the bar imposed under section 10A was clearly attracted. This was the case. Now, next case is Mohan Gems and Jewels. Mohan Gems and Jewels. Ramesh.
Sir, I think it is Union of India versus Vijay Kumar, sir.
Huh?
I think it is Union of India versus Vijay Kumar.
Yes. Union of India versus Vijay Kumar. Yes. यूनियन ऑफ इंडिया वर्सेस विजय कुमार. यूनियन ऑफ इंडिया विजय कुमार में इशू क्या था? उसमें ये था कि whether ownership belongs to the government of India, whether spectrum being under contract can be subjected to proceedings under section 18 of the code, whether spectrum license is subject to proceedings under the code and it overrides the provisions contained in the Telegraph Act, Wireless Telegraphy Act and the Telecom Regulatory Authority, whether spectrum can be treated as security interest and what is the mode of its enforcement, whether as per the revenue sharing regime and the provisions of the Telegraph Act, the dues can be said to be operational dues, whether natural resource would be available to use without payment of requisite dues, whether such dues can be wiped off by resorting to the proceedings under the code, and comparative dues of the government and secured creditors, whether the spectrum or right to use spectrum can be made part of the resolution plan, whether a license, quota, concession by the government is covered as an asset of the CD. So these were the various issues which were involved in this case. Now, what was the decision? So the first point to see is whether it is an asset of the CD. So it is submitted that section 14 only covers what is not permitted during moratorium and does not provide for what is or what is not an asset of the CD. Okay. So there was no vesting of right, there being only a permission to operate the business and use spectrum subject to payment of fees and compliance with terms and conditions. So they said that the right to use the spectrum, there is only right to use and it is not a vested right. So the client has been given only a permission to operate the business, but subject to payment of fees and compliance with terms and conditions. Now, what is the nature of license? So they said the license agreement is in the nature of a contractual arrangement between the central government and the telecom service provider. The right to use spectrum is an intangible asset of the licensee and can be subjected to insolvency proceedings. Now, nature of debt and status of DOT. So they said, apart from the dues payable to the government, the consequence of parting of the privilege by central government in grant of license to telecom companies under the Telegraph Act, the dues payable to the government would fall within the ambit of operational dues, thereby clothing the central government licensor with the status of an operational creditor. The licensor not only retains the power to suspend, revoke, or terminate the license for breach of its terms, but also can levy penalty in the nature of fine for the breach and enhanced penalty for continued breach. The grant of license in lieu of consideration would be in the nature of dues payable to the government, thereby falling within the definition of operational dues. In spectrum sharing, a right to use spectrum remains with the telecom service provider, whereas in spectrum trading, it gets transferred from the seller to the buyer. Dues payable to the licensor continue to be operational dues being payable primarily in terms of the license agreement. So spectrum cannot be treated as security interest, because another point was how you will enforce this security. So they said that the tripartite agreement, according priority or first charge to DOT, the spectrum cannot be treated as a security interest by the lenders. That apart, it being within the domain of licensor to suspend, revoke or terminate the license. Agreement, besides being empowered under section 20A of the Indian Telegraph Act to levy fine for contravention of any condition contained in its license, the security interest, if any, in the hands of lenders would be so fragile and vulnerable that would seriously jeopardize its enforcement. In view of this finding, we need not consider the mode of enforcement of security interest. Now, what is the conclusion basically? So they said the spectrum is a natural resource and the government is holding the same as Sastui trust. It is holding it in trust. Spectrum being intangible asset of the licensee, telecom service provider, telecom company or corporate debtor can be subjected to insolvency or liquidation proceedings. Dues of the central government, they are operational dues. Deferred or default payment installments of spectrum acquisition cost also fall within the ambit of operational dues. As per revenue sharing regime and the provisions of Indian Telegraph Act, the nature of dues payable to the licensor continue to be operational dues, which are payable primarily in terms of the license agreement. Natural resource would not be available to use without payment of requisite dues. ऐसा नहीं कि natural resource है तो उसकी payment करने की जरूरत नहीं है. Triggering of corporate insolvency resolution proceedings by the CD with the object of wiping off of such dues not being for insolvency resolution but with malicious or fraudulent intention would be impermissible. भाई ऐसा नहीं कि आपने किसी के पैसे देने हैं, सोचो मैं तो CIRP स्टार्ट करा देता हूँ, उसकी पैसे देने नहीं पड़ेंगे, तो ये इंटेंशन नहीं होनी चाहिए. ठीक है. So telecom service providers have the right to use spectrum under license granted to them. They cannot be said to be the owners in possession of the spectrum, but only in occupation of the right to use the spectrum. Ownership of spectrum belongs to nation, with government only being its trustee. Possession correlates with the ownership right. Under section 18 of the IBC, the IRP is bound to monitor the assets of the corporate data and manage its operations, take control and custody of assets over which the corporate data has ownership rights, including intangible assets, which includes right to use spectrum. Trading in intangible assets like use of spectrum derives strength from the terms and conditions of the license agreement. So they say this particular clause vests in licensee a right to transfer or assign the license agreement with prior written approval of the licensor and subject to fulfillment of conditions which include payment of past dues in full till the date of transfer. भाई ऐसा नहीं कि आपने पेमेंट तो करी नहीं और आप आगे बेच दो वो लाइसेंस. ठीक है. On the other hand, insolvency proceedings arise out of default in discharge of financial or operational debt and are triggered for insolvency resolution of corporate persons in a time-bound manner for maximization of value of assets of such persons. So while a license can be transferred as an intangible asset of the licensee or corporate debtor under insolvency proceedings in ordinary circumstances, however, as the trading is subject to clearance of dues by seller or buyer, as the case may be, the transferor or seller or transferee or buyer being in default would not qualify for transfer of license under the insolvency proceedings. Okay? The spectrum cannot be utilized without payment of requisite dues, which cannot be wiped off by triggering CIRP under the code. The defaulting licensees, telecom companies, cannot be permitted to wriggle out of their liabilities by resorting to triggering of CIRP by seeking initiation of CIRP under section 10. इसीलिए section 10 वाली application है normally accept नहीं करते, not for the purpose of resolution, but fraudulently and with malicious intent of withholding the huge arrears payable to the government, obtaining moratorium to abort government's move to suspend, revoke or terminate the licenses, and in the event of a resolution plan being approved, subjecting the central government to be contented with the peanuts offered to it as operational creditors within the ambit of distribution mechanism contemplated under section 53. So the tripartite agreement according priority or first charge to DOT, the spectrum cannot be treated as security interest by the lenders. In view of this finding, we need not consider the mode of enforcement of security interest. So basically ये काफी सारी बातें इसमें decide. अगला केस है आपका मोहन जेम्स एंड ज्वेल्स प्राइवेट लिमिटेड. ये मोहन जेम्स एंड ज्वेल्स पे क्या था, इसमें यह था कि an application was filed by the liquidator seeking for closure of the liquidation process as per regulation 45(3)(a) of the liquidation process regulations, as the corporate debtor was being sold as a going concern in the e-auction held on 20th November, declaring Mr. Vijay Verma the first respondent as the highest bidder at a price of this 5,51,99,000. However, the adjudicating authority ordered to dismiss it. ठीक है. अब ये पहुंच गए NCLAT में. तो इशू इन्वॉल्व क्या है? इशू इन्वॉल्व ये है कि whether the liquidator is authorized to sell the corporate debtor as a going concern pursuant to regulation 32, whether adjudicating authority was correct in concluding that regulation 39C of CIRP regulations and 32A 45(3) of the liquidation process are inconsistent with section 54 of the code, whether the interpretation by the adjudicating authority of the provisions of the code and liquidation process regulations in the order impugned is contrary to the scope and spirit of the IBC. तो हमें इसके लिए क्या पढ़ना पड़ेगा? हमें आपको रेगुलेशन 32A भी पढ़ना पड़ेगा और रेगुलेशन 45। ठीक है, तो इसमें डिसीजन क्या हुआ? इसमें ये हुआ कि liquidator can sell the business of the corporate debtor as a going concern. So it is seen that the Honorable Apex Court in a catena of judgments has time and again observed that liquidation should be the last resort. Only if the resolution plan submitted is not up to the mark, and even in liquidation, the liquidator can sell the business of the corporate debtor as a going concern. ठीक है, तो रेगुलेशन 32A and 45(3), which were inserted in the liquidation process regulations subsequent to these cases, specifically define the process for sale of corporate debtor or its business as a going concern. Regulation 32A(1) emphasizes the importance placed on transfer of the corporate debtor or its business on a going concern basis. So adjudicating authority, they said, NCLT said that adjudicating authority crossed its jurisdiction. The sale of the corporate debtor company was carried out by the liquidator in accordance with the regulations. However, the adjudicating authority has, apart from traveling beyond its jurisdiction in making observations regarding the power and functions of framing the regulations by the IBBI, has also not appreciated the ratio laid down by the Honorable Supreme Court in a catena of judgments, that the liquidation of the company is to be seen only as a last resort, and every attempt should be made to revive the company and to continue as a going concern. The legality and propriety of any regulation, notification, rules, act cannot be looked into by NCLT or NCLAT. This is also an important issue on which they can ask the question. So they said that NCLT or NCLAT should not go into the legality or propriety of any regulation, notification, rules or act. Okay. The tribunal can only ascertain whether the procedures provided for under the Code or Companies Act are being followed or not. Adjudicating authority cannot go beyond this. So these two are the important points on which they may ask questions. So this NCLT said that the liquidator has rightly followed the procedure. The code does not prevent the closure of liquidation process in the instance the corporate debtor is sold as a going concern. Pursuant to Regulation 32E, following a closure report filed under Regulation 45(3)A of the liquidation process regulations. It would be contradictory to observe that closure of liquidation proceedings cannot be done. देखो दोनों ऑप्शन होती है. If you are sold as a going concern, तो डिसोल्यूशन तो होगा नहीं कंपनी का, है ना? क्लोजर रिपोर्ट जाती है, अदरवाइज डिसोल्यूशन होता है. And only dissolution is provided under the code. So it would be contradictory to observe this. This would demolish the very spirit and objective of the code. It can be safely construed that before the completion of 270 days, if no decision under Regulation 39C is taken by the COC, only Regulation 32A is to be followed. ये भी एक important point है कि if no decision under Regulation 39C is taken by the COC, only Regulation 32A is to be followed. तो इस पे भी question बना सकते हैं. So additionally, in the instant case, the application under Section 33 of the Code seeking liquidation was filed prior to 25th July, on which date Regulation 39C was inserted. Therefore, question of COC passing any resolution does not arise, as the liquidator has rightfully followed the procedure specified in Regulation 32A of the liquidation process regulations. अगला केस है हमारा नितिन चंद्र नायक वाला. तो नितिन चंद्रकांत नायक, इसमें क्या इशू था? इसमें यह है कि जो appellant promoters and suspended directors of the CD, Simrat Foods and Hospitality Private Limited, they have filed this appeal against the order of the NCLT. And what are the grounds of appeal? The resolution plan has provision to transfer personal properties of the appellants who had given their personal properties as security in favor of the corporate debtor. ठीक है? Against whom the corporate debtor took loan. अब इसमें ये था कि क्या पर्सनल प्रॉपर्टीज भी आप ले सकते हो क्या गारंटर्स की? So the issue called is whether in a CIRP against corporate debtor could the same be treated as a resolution process against personal guarantors, so as to transfer personal properties of the personal guarantors in CIRP of the CD. So arguments put forth were that the resolution plan has to be with respect to the property of the corporate debtor and cannot enforce action against the properties of the shareholders or directors or guarantors without proceeding against them. You have to separately proceed against them and you cannot club these two things. Okay? So analysis and decision. So property of guarantor is not property of CD. This was the point basically. So what it says, sub-clause F of regulation 36(2) provides that the information memorandum should give details of the guarantees that have been given in relation to the debts of the corporate debtor by other persons, specifying which of the guarantors is a related party. ये point information memorandum में लिखा हुआ है, ठीक है ना, कि कौन से गारंटी दी हुई है और उसमें कौन सी related party है. Thus, reference to details of guarantees given by the related party has to be there. That reference does not make property of guarantor a property of the corporate debtor. ठीक है ना. अब इंफॉर्मेशन मेमोरेंडम में लिख दिया तो इसका ये मतलब नहीं है कि वो प्रॉपर्टी कोई कॉर्पोरेट डेटर की हो गई. ठीक है, उसके लिए क्या है, सेक्शन 36(2)(a is there. A resolution plan as approved by the adjudicating authority is in contravention of the provisions of law along with material irregularities. The resolution plan would be blank check given to proceed even with regard to any other property also of the personal guarantors. Further, without resorting to appropriate proceedings against the personal guarantors, this is irregular exercise of powers. According to section 61(3) of the code, that the resolution plan as approved by the adjudicating authority is in contravention of the provisions of the law. Only after portion of part 3 has been applied to personal guarantors of corporate debtor, one would have to resort to those provisions under IBC if personal guarantors of corporate debtor are to be proceeded against. In resolution plan of corporate debtor, provision relating to right of financial creditor to proceed against personal guarantor can be there. ठीक है ना, but enforcement of such right has to be as per the provisions of law. ठीक है, वो आपको फिर आप पार्ट 3 में जाना पड़ेगा, पार्ट 2 में नहीं जा सकते. तो कंक्लूजन ये था कि ये अपना NCLT ने अपील अलाउ कर दी और जो NCLT का ऑर्डर था उसको क्वेश कर दिया और रेजोल्यूशन प्लान जो है उसको रिजेक्ट कर दिया, क्योंकि रेजोल्यूशन प्लान में लिख दिया था ना कि भाई इसकी प्रॉपर्टी को भी मान लो. All actions taken in consequence of the impugned order approving the resolution plan shall stand set aside. As the insolvency resolution process period under section 12 is already over, the matter is remitted back to the adjudicating authority to pass appropriate order of liquidation. तो remit back कर दिया NCLT को for passing liquidation order. Next case हमारा आता है जयेश एंड सिंघारे का. इसमें केस में क्या था, इस केस में ये था कि this appeal has been filed by the resolution professional of corporate debtor Aristo Developers Private Limited. The respondent monitoring agency of the corporate debtor is formal party. तो grounds of appeal क्या है? Grounds of appeal ये है कि this appeal is filed against observations and findings of the adjudicating authority NCLT. So they said, while approving the resolution plan submitted by the successful resolution applicant Prestige Estates Projects Limited, the adjudicating authority disagreed with the committee of creditors, which has approved success fees to the resolution professional of an amount of 3 crores. So the issue here is the COC has approved the success fees. So whether adjudicating authority can reject it, adjudicating authority disagreed with this. So this was the issue. So first is, can resolution professional charge success fees, and whether approval of the success fee was a commercial decision of the COC and the adjudicating authority should not have interfered with the same while approving the resolution plan and directing distribution of the amount set apart for success fees. So this was the issue. So code of conduct to be followed by the insolvency professional. Reasonable fees. Code of conduct talks of reasonable fees. So insolvency professional is to abide by the code of conduct as mentioned in section 282, including clause A of thereof. Referring to section 2082A, it is submitted that insolvency professional is duty bound to take reasonable care and diligence while performing his duties. The resolution professional can charge remuneration only in a transparent manner, and the remuneration should be a reasonable reflection of the work and should not be inconsistent with the regulations. Circular dated 12th June 2018, the IBBI has directed the insolvency professional that the fees payable to them should be reasonable, that the same should be directly related to and necessary for the CIRP, that the fees should be determined on an arm's length basis in consonance with the requirements of integrity and independence, that it should not include fees or other expenses not directly related to CIRP. Section 208(2)(a) of the IBC requires the insolvency professional to take reasonable care and diligence while performing his duties, including incurring expenses. Regulation 32 of CIRP regulations permits the COC to fix the expenses to be incurred on the resolution professional and by the resolution professional. The expenses are to include the fees to be paid to the resolution professional. Now, interpretation of charging success fees. So, if the resolution professional seeks to have success fees at the initial stage of CIRP, it would interfere with independence of a resolution professional, which can be at the cost of the corporate debtor. If success fees is claimed when the resolution plan is going through or after the resolution plan is approved, it would be in the nature of gift or reward. Okay. Success fees term is contrary to what IBBI provided in its circular dated 16th January 2018, that the insolvency professional shall render service for a fees which is a reasonable reflection of his work. The fees has to be related to acts performed or to be performed for furtherance of the CIRP. For dues or expenses actually incurred, it has to be directly related to acts done or expenses incurred which are necessary for the CIRP. The role of the RP has to be like a dispassionate person concerned with performance of his duties under the code for reasonable fees, and it cannot be result oriented. Then they refer to Regulation 34A of the CIRP regulations. So Regulation 34A of the CIRP regulations relates to disclosure of costs. The regulation specifies that the IRP or RP shall disclose item-wise insolvency resolution process cost in such manner as may be required by the board. It cannot be said that charging of success fees is within the provisions of the code or regulations. By indirect reference in a circular, it cannot be accepted that success fees as sought is legally chargeable or payable. Now, another point is whether it is a commercial decision of the COC. When the fees have to be on the basis of the case and work performed or to be performed, the reasonability or otherwise would be justiciable. By pushing in a big amount at the last moment in the name of success fees for the resolution professional and making it part of CIRP cost at the time of approval of the resolution plan does not make the same a commercial decision of the COC. Fees payable to IRP or RP, the resolution applicant and the other stakeholders other than those present of COC would not know what is being hived off from the beneficiaries of the resolution plan. भाई आप अगर आरपी को दे दोगे तो उनका हिस्सा कम हो जाएगा ना. तो fees payable to IRP or RP have been made part of CIRP cost so as to safeguard interest of the IRP or RP. Section 30, subsection 2 provides that the resolution plan should provide for payment of insolvency resolution process cost in a manner specified by board in priority to the payment of other debts of the corporate debtor. The protection is to the CIRP costs validly incurred. The interest of IRP or RP cannot be equated with the interest of the corporate debtor and other stakeholders. Creditors. Fees cannot be disproportionate to eat into the percentage of other claimants of the corporate debtor. Now they deliberated on the nature of success fees also. So they said the success fees, it is more in the nature of contingency and speculative, and it is not part of the provisions of the IBC and the regulations, and the same is not chargeable. Apart from this, even if it is to be said that it is chargeable, in the present matter, the manner in which it was last minute pushed at the time of approval of the resolution plan and the quantum are both improper and incorrect. नेक्स्ट केस देख लेते हैं, स्टेट बैंक ऑफ इंडिया वर्सेस एथेना एनर्जी. ये लास्ट केस देख लेते हैं ना, बाकी कल कर लेंगे. तो इस केस में क्या हुआ था? इस केस में ये था कि द एप्लीकेशन अंडर सेक्शन 7 for CIRP was filed as borrower committed default in repayment of the financial assistance provided to the borrower. Simultaneously, CIRP application was also filed against the guarantor. Okay. However, the respondent opposed, being the application filed claiming that the application was arising out of the very same transaction and the very same common loan agreement, duplication of claim. Okay. However, the adjudicating authority rejected the application filed against the respondent. Hence, this appeal has been filed under section 61 subsection 1. 61 subsection क्या है? वो appeal to NCLT की बात करता है. Against the impugned order passed by the NCLT. Now, what is the issue involved? The issue involved is whether the corporate insolvency resolution process can be initiated against two corporate guarantors simultaneously for the same set of debt and default. In short, whether application can be filed against the principal borrower as well as the corporate guarantor. Now, arguments put forth. When remedy is available against both, application can be maintained against both, and only at the stage of disbursement, adjustments may have to be made. So what was the decision basically? The decision was that we have to see the provisions of the Indian Contract Act also, which say that the liability of the principal borrower and guarantor is coextensive, and the creditor is entitled to proceed against either or both, and no sequence is required to be followed. Now, provisions under IBC. Referring to section 58A, H and I of IBC, it is argued that IBC treats the principal borrower and guarantor similarly. Reliance is placed on section 60 subsection 2 of the IBC to submit that simultaneous application could be filed against the borrower as well as the guarantor, and that the same could also be maintained. If we see section 60 subsection 2, so then what it says? Section 62 subsection 2 talks of a scenario which says that where CIRP is pending before NCLT, an application relating to insolvency resolution or liquidation or bankruptcy of a corporate guarantor or personal guarantor shall be filed before such NCLT. So if we see section 60 subsection 2, it is talking of a scenario where two applications can be filed against the CD and the guarantor both. If the above provisions of section 60 subsection 2 and 60 subsection 3 are kept in view, it can be said that IBC has no aversion to simultaneously proceeding against the corporate debtor and the corporate guarantor. If two applications can be filed for the same amount against principal borrower and guarantor, keeping in view the above provisions, the application can also be maintained. Okay. Now it is for such reason that subsection 3 of section 60 provides. ठीक है, अब वो कहता है 60 सबसेक्शन 2 के बाद 60 सबसेक्शन 3 भी पढ़ो. वो क्या बोलता है? वो ये बोलता है कि if insolvency resolution process or liquidation or bankruptcy proceedings of a corporate guarantor or personal guarantor, as the case may be, of the corporate debtor is pending in any court or tribunal, it shall stand transferred to the adjudicating authority dealing with insolvency resolution process or liquidation proceedings of such corporate debtor. ठीक है, अगर गारंटर और सीडी की प्रोसीडिंग दोनों अलग अलग अथॉरिटीज के पास चल रही हैं तो वो सेम एनसीएलटी में ट्रांसफर हो जाएंगी. Apparently, and for obvious reasons, the law requires that both the proceedings should be before the same adjudicating authority. So simultaneous remedy is central to a contract of guarantee, and where principal, borrower and surety are undergoing CIRP, the creditor should be able to file claims in CIRP of both of them. IBC does not prevent this. But बात यह है कि आपको लेना तो टोटल पैसा वही है ना. वो कहते हैं भाई आप CIRP तो स्टार्ट कर रहे हो ना, आपको भी पैसा तो नहीं मिल रहा ना. मान लीजिए सपोज यू इनिशिएटेड CIRP अगेंस्ट द कॉर्पोरेट डेटर, आपने 100 करोड़ लेने, आपको 80 मिल गए, बाकी के लिए पर्सनल गारंटर से ले लोगे. आपने पर्सनल गारंटर से पहले ले लिए, बाकी CIRP में ले लोगे. लेने तो टोटल 100 ही है. ठीक है, तो ये भी हो गया. तो आज की रामायण यही समाप्त होती है. बाकी जो है केसेस कल करते हैं, ये मैं शेयर कर दूंगा आपसे.
ठीक है
सर
सर.
ये फाइल हाँ जी स्टडी ग्रुप में भी शेयर